Thank you, Senator Cornyn. Good morning. Welcome to Washington. It is terrific to be with a room full of Texans. It is terrific to see each of you again. As many of the people in this hearing know, Senator Cornyn and I, 4 years ago, created a bipartisan Federal Judicial Advisory Committee consisting of esteemed members of the bar throughout the state of Texas. It is bipartisan. It includes Republicans and Democrats. It includes leaders in every region of the state to make recommendations on judicial appointments. And each of the 5 nominees who's sitting before us is the product of that process. Each of you has been through that, has been through vigorous interviews, has been through the scrutiny of your colleagues and the scrutiny of your peers. And it is designed to be an exacting process, but it is also designed to be a process that helps the cream rise to the top and helps produce nominees who will be the very best at what they do at the bench, who will be learned in the law, who will be faithful to the law and faithful to the Constitution, and who will bring honor to the judiciary and uphold the integrity of our courts. And so I congratulate each of the 5 of you at making it through the process with such flowing colors. And I'd like to ask each of you in this hearing to share, and we've had conversations, all of us have had conversations privately, but in this hearing I'd like to ask each of you to share your judicial philosophy. Describe what a federal judge should do and what a federal judge shouldn't do. And we'll start with you.
Thank you, Senator. Good to see you again, sir. My judicial philosophy that I've been fortunate to practice for the past 7 years as a United States magistrate judge and would do, if confirmed, continue to do as a district judge, is one of restraint. The philosophy that I've always used is to listen intently and earnestly to litigants before me, to treat them with respect and dignity, that not only that they want, but that they deserve, and to faithfully adhere to the rule of law, and to apply the constructs of statutory authority, to apply the Constitution, as well as the precedent of the United States Supreme Court and the Fifth Circuit. That's what I would continue to do. You asked what a judge should not do. I don't believe a judge should ever, nor will I ever. I pledge to you never to operate it with judicial activism, as we call it, operating outside the proper exercise of judicial authority with regard to personal view or political affiliation or anything of that nature. Thank you.
Thank you.
Yes, sir.
Senator Cruz, I believe that a judge should be well prepared, that a judge should exhibit humility, that he should be even-tempered and patient. I believe that he should treat all the litigants that come before him, bless you, as well as the lawyers that appear before him with dignity and respect, allow the litigants to feel that they have been heard and that they have had their day in court, and which will probably lead to more acceptance of the decision that they do receive. I also believe that there should be great respect for the rule of law, that we as judges should impartially evaluate the facts without any reliance on our own opinions or biases, and apply the rule of law to those facts that we have determined and make a decision accordingly.
Senator, my philosophy would stem from humility, because I think if a judge remains humble, all of the best qualities flow naturally from there. Those qualities are fidelity to the rule of law, an understanding that while the judge plays a critical role in that rule of law, it's a limited role. The judge will be respectful and courteous to the parties and the lawyers and the juries that are before it. And a judge will approach docket and docket management with diligence. I think those are the qualities that the best judges exhibit, and I would commit to those qualities.
At my formal swearing-in ceremony 14 years ago, I made a pledge to which I have endeavored to keep. I pledged to work hard, to be fully prepared for each matter, so that I could fully understand the legal issues that were before me, as well as the positions and concerns of the parties and the litigants, to correctly, faithfully, and impartially apply the applicable law, and to bring honor to the court and uphold the dignity of the judicial process for all who came before it so that they could understand it and feel that they were a part of it. Represented or unrepresented, all were to be treated equally. We spoke at our meeting about the definition of judicial activism. Black's Law Dictionary, I remember telling you that I did my research on that because I wanted to be sure what that meant before I spoke on it. Black's Law Dictionary has defined judicial activism as a philosophy whereby judges allow their personal beliefs on public policy, among other factors, to guide their decision-making. And I can say to you that I have endeavored over the past 14 years and will continue in my current job to endeavor to never allow my personal beliefs to influence my decision-making, but to faithfully and correctly and impartially apply the law.
Senator, my judicial philosophy is strict adherence to the rule of law and the doctrines of stare decisis and judicial restraint. And I'm in agreement with my fellow nominees that judicial activism is what a federal judge should not do.
Several of you have addressed judicial activism, but I'd like to ask each of you to how you would differentiate activism from the proper role of a judge. It's one thing to use a label, but what's the difference?
Senator, I would think that the difference is, the most glaring to me, is to bend an outcome or a ruling to one's personal beliefs or political views, rather than applying strictly the rule of law. And as Mr. Hendricks mentioned, the fidelity to the law. And I don't know that I could give you an example. I think that to me is what that means, is that it's stepping outside of the role of the proper exercise of judicial authority to make some outcome occur that I wished to happen or that a judge wished to happen that was, of course, inappropriate, but outside the rule of law, not what the law would require. That's why I told you I would faithfully adhere and will continue to the rule of law.
I believe that judicial activism is when a judge makes decisions on what he feels the outcome of the case should be, not relying on an independent review of the facts without interjecting opinion or belief. So judicial activism to me would be forsaking the rule of law and instead inserting your own personal beliefs into the decision-making process, which I would not do.
Senator, I define judicial activism as when a judge allows his or her own policy or personal preferences to guide the decision of a case instead of the rule of law that applies to that case. The proper role of judge is to recognize that that judge serves an important but a limited role, and that role is to apply the law, not make the law. And when we forget that, the foundation, the rule of law of our society and the separation of powers erode. And I would not allow that to happen.
I agree with what my fellow nominees have said. I would add that it is also important to stay within the record, to look at the facts only that are presented to us in making our decisions, and to rule only on the issues that are presented to us and not to go outside of that.
In your judgment, what is the role of the original understanding of provisions of the Constitution in interpreting and applying the Constitution?
My understanding, Senator, is that the original meaning of the document, the Constitution, is as it should be today. The original framers, as they meant it at the time, is what originalism means to me.
And I would agree with that as well. I believe that there have to be certain changes in interpreting the Constitution based upon technological advancements, things of that nature, but the original language and intent of the Constitution should stay firm.
Senator, the Supreme Court has recognized that the original intent of the drafters and the original meaning of the provisions of the Constitution are important and highly relevant in construing the Constitution. I, of course, as a district court judge, would follow that precedent, and I recognize that the original intent and meaning are important. The meaning of our Constitution does not change with the whim or the views of society. It was built to last, and it has lasted.
I look to the existing Supreme Court precedent on the interpretation of the Constitution and its meaning.
And so, what relevance, if any, in your judgment, does the original understanding of the terms of the Constitution have in constitutional adjudication?
It is extremely important, and I will look to the Supreme Court precedent that tells me exactly how I should weigh the meaning of the terms in the Constitution and what it says. I will not seek to interpret it on my own. I will look to the existing case law and the binding Supreme Court precedent that will tell me how it is to be interpreted.
I'm in agreement with Mr. Hendricks that it's the original public, originalism is the original public meaning at the time of the framers of the Constitution.
And let me ask each of you, in your judgment, what role should international law or the judgments of international tribunals play in American constitutional law adjudication?
I don't believe international law should apply or should be considered with regard to the United States Constitution. If a provision before me is were ever to come before me where I was ruling on an international contract or something along those lines, I might view that international law to ensure that there might possibly be a reason that, of course, we want to hold the other party to the same constructs as we're holding ourselves, the United States of America. Other than that, because there are reasons, I believe, that we want to give incentives, of course, to international bodies to comply with any provision that we have. But international law would not apply to or have any role in my interpretation of the United States Constitution.
I also agree that international law should have no bearing or input on our construction of constitutional issues.
I agree, Senator.
So do I, Senator.
As I understand the question, none.
Well, let me say finally, I know that each of you has, I believe, brought your families up here, and I do hope, in addition to a hearing this morning, that you take some opportunity to enjoy the city and go see the Lincoln Memorial. And for the families of each of the nominees, I want to congratulate you as well. Being nominated to the federal bench is a big, big deal. And I know each of you are proud of the men and women sitting at this table, and you have good reason to be proud of them. And I would encourage you while you're here with your families, for all of you to reflect on the incredible importance, the foundation that rule of law is for our nation. that for most of the history of mankind, rule of law has not been something people can count on. And an independent judiciary that follows the law, that doesn't simply decree by whim or arbitrary judgment, has been an exception for much of human history. And with that, I want to congratulate each of you on your nominations. We will keep the record for this hearing open for 1 week. And with that, this hearing is adjourned.